Hello and welcome to the BRR Legal Brief, bringing you the latest legal issues affecting corporate Australia. And today we bring them to you live from Gilbert and Tobin. I'm Kate Ritchie, and today we're looking at bank fees, with the High Court's ruling last week essentially broadening the interpretation of what may be considered to be a penalty fee. Joining me to discuss the decision and the potentially massive implications for commercial transactions is Rani John, who's a partner at Gilbert and Tobin. Rani, welcome.
Thanks very much, Kate.
Well, Rani, potentially massive implications, as I said. But firstly, how does last week's ruling differ from what was in place before?
Okay, so just some context about what a penalty is. If a contractual provision requiring an amount to be paid is found to be a penalty, then essentially it's unenforceable by a court. A court will refuse to enforce that payment. And something will be a penalty, or it was understood to be a penalty, if there's an event of default which triggers a payment obligation, and the amount that has to be paid is not a genuine pre-estimate of the loss that would result from that event, and it's out of all proportion to what would follow from the event. Now, the understanding prior to the High Court's decision had been that it was only where the triggering event was a breach of contract that it would be a penalty, and if it was another sort of event, then the doctrine of penalties wouldn't apply. So to give an example, if you and I have a contract and if the contract says if you overdraw your account with me, you must not do that, but if you do, I'm going to charge you a fee of $50. Now, if that $50 is not a genuine pre-estimate of my loss from you overdrawing your account, and it's out of all proportion to the loss that I would suffer, then it's a penalty because it's triggered by a breach of your contract with me. However, if I'd structured the contract so that it said, it didn't prohibit you from overdrawing your account, but it said, if you do overdraw your account and you choose to do that, then I'll extend credit to you and I'll charge you $50 for it. In those circumstances, the triggering event was not a breach of contract. And so it was understood that in those circumstances, the doctrine of penalties wouldn't apply, so you wouldn't need to consider issues like, is the amount a genuine pre-estimate of loss? So the High Court's decision has changed that. And what the High Court has held is that the doctrine of penalties extends to circumstances where the event triggering a payment is not a breach of contract but some other kind of event.
Okay, well, Rani, what will now need to be shown or considered when we look at things like over-limit fees and dishonour fees?
So it's necessary now for the court to look at the substance of those fees. In the ANZ case, the ANZ had, at an earlier point in the decision, in the case, conceded that the fees that are being challenged are not genuine pre-estimates of the loss estimated at the time that the contracts were entered into. And that makes sense. These are all standard form contracts entered into with hundreds of thousands of customers. So a key now for the ANZ will be to show that nevertheless the amounts of those fees are not out of all proportion to the loss or the cost that they're going to incur when the triggering events occur. So when someone overdraws their account, the loss that they suffer is not disproportionate to the fee that they're charging.
Well, is this a big loss for ANZ? Is this going to be something difficult for them to show when the case does return to the federal court?
Well, I think it's an important argument that they had prior to this High Court decision, that there are a whole series of categories of fees being challenged in the class action which were not capable of being assessed as penalties because they weren't triggered by breaches of contract. And that argument now has gone. So at least theoretically, the dollar exposure to the bank is greater because there's a larger range of fees that are capable of being assessed as penalties in this way. So there's two key arguments for the ANZ. The first is the one that we just talked about, which is showing that the amount of the individual fees that were being charged was not disproportionate to the cost or the loss that they incurred when the triggering events occurred. The second argument is an interesting one. It was actually flagged by the High Court itself at the end of its judgment, and that is there was a finding by the primary judge in the class action that that some of these fees were fees for services. That is, when you overdraw your account, essentially what's happening is that the bank is providing you a service of, giving you further credit. And the High Court pointed out that the class had not actually challenged that finding in its appeal to the High Court, and it hadn't tried to argue about whether or not in those circumstances you could still have the doctrine of penalties apply. That is, does the doctrine of penalties apply where what you've got is a fee for service? So that is, and they emphasise this is very much a live issue. It's not one that was dealt with by the High Court, and therefore it will need to be dealt with at the trial. So it'll be interesting to see how that plays out.
Yeah, certainly. Well, it's not only banks that charge these kinds of fees. How wide-ranging are the implications from this decision?
Yeah, I think pretty significant. I mean, there's a whole range of businesses that will be affected by this decision, particularly, I think, large-scale retail businesses, utilities companies, telecommunications companies, where they have standard form contracts and fees or payments that have to be made when certain events occur. Now, it may well be that those contracts have been structured in the past on the understanding that the only time you needed to worry about the doctrine and penalties was where it was a breach of contract triggering those fees. Now the scope is much broader, so I think it will be important for businesses to revisit their contracts in light of that.
Well, for those businesses that might be affected, should they be re-looking at their contracts now, or what would be your advice for them in the coming months?
Sure. I mean, I certainly think that review of standard form contracts is important, and assessing it in light of the High Court's decision, and thinking about whether there are payments provided for in your contracts that are triggered on events of default which are not just breaches of contract. And if that's the case, can those amounts be justified as either genuine pre-estimates of loss or cost, or at least not out of all proportion to the loss that's going to result from those events? And I should say there's nothing wrong with specifying amounts to be payable in contracts on the occurrence of an event of default, whether that's a breach or not. It's really about being able to justify the quantum of those fees.
Well, some good tips for businesses there, and I certainly think everyone will be watching this decision closely, particularly the other banks, to see what does happen. Rani, thank you so much for joining us today.
Thanks, Kate.
And thank you, viewers, for joining us live at Gilbert and Tobin. We hope that you can join us next week for our legal brief.